So following your time in the District Court, you became a judge of the Land and Environment Court in
85.
85, exactly, as you say, 2 years to that day. Now, the Land and Environment Court was quite new. So you were probably one of its first judges, weren't you?
Well, I wasn't the first judge, obviously. The first three judges were appointed in 1980, and I joined as an additional judge in 85. So there was still the three. No, I think what happened is Jim McClelland had retired, and I replaced him, and Neil Bignold became an additional judge. So we had four judges. That was Gerald Cripps, who became the chief judge, Ted Perignon, and Neil Bignold and myself.
Were you excited to be part of a new court, or relatively new court?
Absolutely. It was very exciting, and it was quite challenging, but it was terrific to be part of the emergence of a new branch of the law, and I always aim to try to further the principles of environmental law as part of being a judge of that court.
Were you reading judgments from elsewhere that proved to be instrumental in your own approach to environmental law? Was there judgments going on in other parts of the world that had a strong bearing on what you did?
There weren't really. We certainly did, or I certainly did, read any environmental law judgment from anywhere in the world. But in those early days, in the early 80s, we were ahead of the rest of the world. So we were the ones that were making it up. There weren't many decisions from elsewhere in the world that we picked up on that were useful.
Can we just take a step back for a moment? What directly led to the creation of that court? Perhaps you'd like to set that out for us, and then we can get a sense from there as to why everything you were doing was so new.
Well, in the mid to late 70s, it was clear that the planning system was chaotic and needed to be brought up to date. And the Liberal government started to work on that with some green papers. Then there was a change of government, and Paul Lander became the minister, and he was really set on reforming in planning and local government law, and he was very keen on having the idea of having a separate court that would bring together something like a dozen diverse jurisdictions with boards, and this board and that appeal board and this part of the Supreme Court and that, to all in the one-stop shop, as it were, court, and also to, importantly in my view, make it a superior court equivalent in status to the Supreme Court, so that its decisions would be recognised as such. And it was really he and his department's enthusiasm that led to the legislation.
Paul Lander, of course, was another very interesting Attorney-General whose career was cut short, tragically.
Sadly, yeah.
Some say he would have been Premier had he lived.
Well, he certainly was ambitious and he was capable.
So if it hadn't been for him, in a way, we might not have had a Land and Environment Court, do you think?
It's possible. I don't know enough about the intricacies of the politics at the time. It was certainly supported by Neville Wran as Premier and the government generally. And there wasn't that much opposition to it at the time, although there did come some opposition from the bar.
Why?
Well, I think one of the problems was that the court was also to have some non-lawyer assessors, they called them at the time. They call them commissioners today. And the bar didn't feel that you could have non-lawyers making decisions in a superior court as a matter of principle. I think that was, from my memory, which is pretty vague now, the main purport of their opposition.
Did you dispute that?
Oh, I did, because I think the role of the assessors has been quite important, And they were making decisions on the facts. They weren't making decisions on the law. And if they did, in doing that, make a mistake in the law, there was an appeal. So, and it worked quite well.